All right, all right, all right. Today we are going to talk about some issues that keep coming up regularly. I know we've talked about them a lot before, but they continue to come up, and we continue to have some struggles, some issues, or just challenges around. And most of the time, it is in dealing with other agents. So we're going to talk about some of those things. Talk about some of the common things that have been happening that we get the most calls on. And just because literally in the last 2 days, I've had at least 3 or 4 issues just around these matters. We'll also talk about some other contract challenges that we have, getting people to understand what the contract says and having those communications with them. And then also when we jump into servicing our listing, I am surprised at the amount of conversations that I'm having with agents and some of our agents and asking the question, well, when was the last time you ran a comparable market analysis for the property and shared it with the seller? Oh, it's been a while. Okay, when was the last time you gave the seller an update on everything that's come on the market, went under contract, or sold? Um, I talk to them all the time. That wasn't the question. Please, let's focus on the answers to the questions that we're trying to get, because all of them mean something. So we need to do a better job at servicing the listing and servicing the seller. So these are some of the conversations that are coming up. All right, so let's jump in. Let's go straight over to some of these issues and challenges that we have. So I'm going to talk about, we're going to go one at a time and just discuss what's happened, what's come up, and how it impacts us, and how do we communicate these things more clearly, especially typically with these issues. These are going to be agents that we're dealing with. So compensation has been a big challenge for a lot of us, and a lot of us in this business, not just a lot of us in the brokerage, a lot of us outside of the brokerage, all around. And the problem sometimes is we could be dead right when it comes to compensation, buyer agent compensation, seller offering, who's paying, how's it going, how do we ask, what form do we use? We could be dead right, but sometimes we have people on the other side who are more ignorant and just don't understand, and they're not willing to listen or understand or communicate. So let's talk about what's been happening. So we have a scenario that I discussed with someone last night. We have a seller and a seller agent, and we sent over an offer. We called, we discussed with them, is there compensation being offered? No. The seller's willing to pay. The seller's going to pay, I can't remember if it was 2.5%, 3% or whatever. The seller's willing to pay. He'll pay 3%, but he hasn't given us a compensation agreement. Okay, so he's willing to pay 3%, but he hasn't given a compensation agreement. Yeah, just put it in the offer. All right, say less, no worries, send it over. We send over an offer. We check the box for FF, and we include FF. What does Addendum FF say? Addendum FF is referencing a credit from the buyer broker, or a credit from the seller for buyer broker compensation. I'm going to pull it up right now just so we can look at it and see how pretty straightforward it is. It says credit related to buyer broker compensation. All right, awesome. This is revised 824, the 2024 Florida Realtors and the Florida Bar. It says right here. So this form was revised and created by the Florida Bar and the Florida Association of Realtors. The buyer has entered into a separate agreement as may be amended. It's a buyer broker agreement. That's between their separate agreement. It's not putting that agreement into this contract. It's a separate agreement. It just says the buyer has another agreement in which they have to pay somebody. At closing, the seller agrees to credit buyer the sum described below, which for disclosure purposes only the parties agree is related to the buyer's obligation under the buyer broker agreement to pay all or a portion of the buyer broker compensation. Please select the amount. Very simple. Very straightforward. It says seller credits buyer so that buyer can pay buyer broker compensation they've already agreed to in a separate agreement. Pretty much sums up everything, hits every single box, by who, by when, because of what's the reason. It covers everything. But what's the issue? Well, the issue is we have an agent and a seller who says, no, we're not going to accept that. We will not use Addendum FF. Hold on a second. You don't want to use the form that was ratified and revised and incorporated by the Florida Bar, the Florida Legal Association, along with the Florida Realtors, to incorporate legal and real estate to make sure it's compliant and covers all the bases. The lawyers who did this put it together for us, and you're saying you don't want to do that. What did you want to use instead? Here's what they wanted to do. Seller to pay C21 Beggins 3% of the purchase price towards the buyer agent professional service fee. And then their comments were, it's clean, it's simple, and included in the contract, approved and ratified by NAR in 1990. Well, that's a lot there. So basically, it kind of covers some of the bases, but what's the issues with this? Who is the purchase and sale agreement between? Purchase and sale agreement is between the buyer and the seller. That's who that agreement is between. Who is this agreement that they're putting into the contract between? The seller and the buyer's broker. Buyer broker, not a party to the purchase and sale agreement, but they're making them a party to it. Let me ask you a question. Is there a reason that in the contract, whenever it covers inspections, it doesn't say that the inspector is responsible for repairing any damage to the property caused by the inspection? It says the buyer is responsible for that because the inspector is a third party and you cannot dictate something that a third party will do or will accept. Two parties, buyer and seller, cannot dictate what a third party is going to do or accept that they are not a party to that agreement of. So this is basically saying that the buyer and seller are going to dictate what you get and you don't have a choice. Doesn't really work that way. Number one, so the compensation again is between the seller and the buyer's broker. So we need a form between the seller and the buyer's broker, or the compensation between the buyer agent and the buyer. The buyer needs to get a credit for that, and we want it properly referenced inside that contract. And this verbiage it covers it, but why would we not use the form that's been ratified by the Florida Realtors and the Florida Bar? And they said, this is the form we want you to use if you're getting a credit from the seller to be used as buyer broker compensation that's going to be offset, that will offset your buyer broker agreement. And if we ended up having to go in front of a judge and the judge looks at this and says, I see what you wrote in there, but why didn't you use the legal form that was already approved by your organization that you are a member of and pay to do these things? And it doesn't cover this or this or this. Could we potentially be creating problems? Yes. So my opinion is always use the forms that are being provided to us. If it comes down to it, look, we're not going to be the ones that get in the way and cause a contract to not happen, but let's do things the right way. And we can always recommend in a situation like this, you can always recommend they call the legal hotline. Call the legal hotline and ask them if we're getting a credit from the seller to the buyer's broker, how should we do that? It just doesn't make sense to me to not use the predetermined forms. Like I said, if the Florida Bar and the Florida Association of Realtors came together and put documents together so that we could use them to make our lives easier, that's what we should be using. Number one. Number two, he's saying this verbiage was approved and ratified by NAR in 1990. Was this form that was revised in 2024, which is 34 years afterwards, is that before or after 1990? Do you think it's more valid or less valid than what was done in 1990? Are things done differently now? Yes, because there was a new rule that was passed in August of 24 that created some new changes. So we should be using the most updated forms. It's just an issue we continue to come into, and we need to have these discussions. If you don't want to use FF, let's use a compensation. Seller won't sign a compensation agreement, but he wants to write into the contract everything that the compensation agreement says. So what did we do? We just went and took the verbiage from Addendum FF, and we took the verbiage from Addendum FF, and what we said is, let's take this verbiage. At closing, seller agrees. This is the verbiage they've already given us. Let's take this verbiage and let's put it into the additional terms and see if they'll accept it. And when they accept it, we say, hey, by the way, all we did was use the verbiage from the form that you said you wouldn't accept. It's just, again, mind-boggling, just blows my mind. So that's one issue that we keep coming up with and keep coming into. Here's another one that we have, along compensation. Again, compensation is a recurring theme. A buyer agent is working with a buyer, and the buyer is not pre-approved because we haven't seen their form. Okay, is there a problem with that? Yes, no. it depends on how you feel about it. I don't necessarily have an issue working with a non-pre-approved buyer. If we're not spending all day and all time with them, I give them one free one. Because I know that if I can meet somebody face to face, I'm going to do a damn good job and I'm going to show up differently and I'm going to earn their trust. And it gives me another opportunity to connect and build rapport with them, which means they're probably going to sign with me and use me as their agent. So I'll give them one free one. I'm not going to continue to work with them and continue to show homes and continue to do that if they're not willing to do what I asked them to. I gave you something of value. You need to give me something of value now. But we get a call from a buyer agent and she's working with a buyer who the buyer says he's approved, but won't give her the form. And he says, no, I'm good. I've got an 800 credit score. I make this much money. I've got this much money in the bank. I'm going to do a 20% down loan. I've got tons of money. I'm perfectly good. The bank already told me I'm good. They said they'll give me the form as soon as I need it. And I don't need it until I have an accepted contract. And even the bank agreed with me that I don't need it until I have an accepted contract. I'm like, hey, okay. So what do you do then? Buyer wants to make an offer. The buyer saw the home, spent an hour and 10 minutes at the home, loved the home, wants to write an offer. The agent calls and says, hey, I have a buyer who's not pre-approved, but they won't give me a pre-approval until we've agreed to terms. What do we do? How would you handle that? How would you communicate with the agent for someone who's saying, I want to send you an offer, but I'm not going to be able to get you a pre-approval until you agree to terms? Do we accept? Do we discuss? Do we negotiate? It's a written offer. So they send over a written offer and we have a duty to present all offers because the offer's in writing. How do we know the validity of their financial status to be able to write that offer and to be able to perform according to that offer? We don't. So what do? We discuss with them and say, hey, maybe, how about this? How about you send over the offer? I'm willing to sit down with the seller. We'll go through all the steps that we need to. We'll get you a counter offer, but it's going to be a verbal counter offer because if I put something in writing and give it back to you and you sign it, we're under contract and I have no verification of how financially qualified you are. So we can come to terms. I'll agree to come to terms. We'll get to that one, Sarah. Perfect. So I'll agree to verbally come to terms with you, and then you're going to have to present that offer back in writing that I can sign, but you're going to need to give me that pre-approval. Well, I'm not sure that he'll do that until he has an accepted offer. Okay, well, what's the other option? How about this? How about send me the offer? Let's review that offer. I'll go through it with the seller. I have a duty to present all offers. I'll explain to them what the buyer's concerns are and not wanting to do this or that or get the approval before a certain time. And we'll see if we can agree to terms. We'll see if we can get something done. And then what we can do is one of the terms of the offer in the additional terms, we can say this contract is contingent upon buyer providing a valid pre-approval letter within the most recent 30 days to the seller within 1 business day, 2 business days. It's contingent on the buyer doing that, providing me a valid pre-approval within the most recent 3 days, provide it to the seller within this number of days of the effective date. Seller reserves the right to cancel the buyer within 1 day if they are not satisfied with the conditions inside the pre-approval. That's something that we can do as well, but make the contract contingent on it. That way the seller has the right and the seller reserves the right if we're not satisfied. Because we told the other agent, said, well, typically before we can accept an offer, we really like to speak to the buyer's lender. I want to make sure that they're on the same page and they're doing the right things and they've taken and reviewed everything that they said they reviewed in the form. And then here's the other challenge. The bank he wants to use is his personal bank, Bank of America. Is it a challenge? Could be. Do they do things differently? Yeah. Do they process on their own timelines? Yeah. Do they need longer to close? Most of the time. Will they give you any information as the listing agent? Typically, no. Most mortgage brokers will disclose information that's not personal and confidential to the buyer that they're allowed to disclose and discuss. Bank of America won't do that. We've had that experience plenty of times. Even though the contract says the buyer authorizes their lender to disclose information to the agents and to the title company, they're not always willing. Is that agent asking 6% total? I'm not sure what you mean by that. So that buyer agent, where that buyer agent was asking for a 3% compensation. So they don't want to give a pre-approval. So let's make an offer contingent on that buyer providing a pre-approval within X number of days after the effective date from a valid financial institution that's dated within the last 30 days, and the seller reserves the right to review it and cancel the buyer within 1 or 2 days if they're not satisfied. Something similar to that. Here's another one. The buyer agent wrote an offer, submitted the offer, and did not include any compensation. There was no FF, there was no compensation agreement, there was no GG, there was no additional terms. Down here, this is what they wrote. On page 13, they wrote 3% next to their name, 3% next to their brokerage. That's what they wrote next to their name. There was no agreement between the buyer and seller. There's no, or buyer agent and seller's broker, or seller and buyer's. There was no agreement between anybody. That's just what they wrote. Nothing else. So we ask, do we address this now, or do we wait for it to be a problem? We address it now. I noticed there was no compensation in the offer, but I can clearly see that they're trying to do something, or they think they're doing something by writing this. That's what we used to do when we had a contract in the MLS, okay, and still absolutely means nothing. Even when MLS made an offering, doing this means nothing. MLS is an agreement between brokerages. So when MLS had compensation offered, the agreement in the MLS and your participation in the MLS was acceptance of the terms of the MLS. So whatever the seller was offering is what you got. If they were offering 2.5% and you wrote 3 here, it doesn't mean you're getting 3 at closing. It means nothing. This is absolutely nothing, means nothing, does nothing, conveys nothing, construes nothing. The only thing that it tells me is that they think or want 3%, and they have no idea what they're doing. Even when it was in MLS, the purchase and sale agreement cannot override an agreement between brokerages that are in the MLS. So when we see this, I'm like, okay, do we address it? Yeah, obviously. So I call, hey, we call them up and say, hey, we do not see any compensation being requested. And here's their reply. Their reply was, yeah, it's there on the last page. We wrote it next to our name. Okay, so that is how you are going to request compensation, even though that doesn't mean anything. I said, well, we said, so that's improper. And that doesn't construe anything. Can you please use one of the proper forms? Either use FF or a compensation agreement in GG. So then they sent over a compensation agreement. And what did the compensation agreement say? The compensation agreement, they did not ask who was paying compensation. They sent a compensation agreement that is now from Century 21 Beggins to the buyer's brokerage. So seller's brokerage to the buyer's brokerage. Well, in this case, the seller's paying the buyer agent compensation. So that's something else that has to be amended. They didn't ask any questions. They just said, I don't need you to ask how much you're offering. You don't need to ask how much compensation you're offering. What we need to ask is who is paying the compensation, so I know how to properly include it inside the contract. That's all I need to know. Who is paying the compensation? Is it the seller or the seller's broker? I just need to know how to properly request it within the offer. And we put that offer together and send it over. What else do we have? So again, we have another one. So a seller was questioning the affiliated business arrangements disclosure. So we have a seller who's very detailed, and he's very, very detailed. He reviews everything, wants to understand everything, goes through everything, has already done his research, has already looked into things prior to, and he shows up into the office to sign our documents, and he's reviewing the ABA, the affiliated business disclosure. For those of you who don't know, but you should, the affiliated business disclosure is a required form from our brokerage. The RESPA laws state that we must disclose to any client anybody that we share in profits with. Same thing with the title company. Title company must disclose anyone that they share in profits with. So there has to be an affiliated business disclosure whenever a brokerage shares in profits with somebody because of RESPA regulations. So our ABA discloses to them that we have an affiliated relationship with this title company, Paramount Title, and here are the fees that Paramount Title could and will charge related to title. So For those, when we look at this affiliated business arrangements disclosure, that's what it says right here. These companies, we share in profit, we own this portion of it, and here are the fees. He was concerned because I went to another title company, his words, I went to another title company and got an estimate and got a quote, and it wasn't the same as this. Yours is way more. I don't see how you could charge this much. Why is it so much more? And this is the title insurance from 0 to 100,000 of liability, 575, from 100 to a million, $5, over a million, 250, over 5 million. These are the what is called promulgated rates. What is a promulgated rate? The promulgated rate, this is an insurance division, title insurance. That rate is a promulgated rate. It is strictly enforced and regulated by the state of Florida. The state of Florida says to the insurance companies, these are the base rates that you must charge for title insurance. They are non-negotiable. They will not change. You cannot change. Sellers can't negotiate. You can't get a cheaper one by going over there. They're promulgated rates that this is what you charge. Strictly enforced by the state and the insurance divisions. Those are rates, non-negotiable. And he's saying, well, that's not true. Yours are more. I'm sorry, I don't know what to tell you. These, I can Google it right now and it'll tell you exactly this. It'll tell you that these are the base rates set by the state of Florida with title insurance called a promulgated rate, and they are strictly enforced by them as well. He wasn't buying it, but he kept saying these numbers like, oh, well, I don't see how I got a quote from another company and it wasn't $13,000. I don't see how you're charging $13,000. And we simply just, I could not understand where he was getting that number from. So we just asked, where are you getting that number from? Because if I take the simple math for the sale of your home and the 575 for the full amount, this is how much it would cost. It's only going to be $2,300. Oh, But, and then we stopped there and he goes, oh, maybe I misread something. All right, so very simple. How about we get the title company in here and the title company will get you a quote and an estimate. Can we ask to see the, yes, we can ask. So what I told him was Paramount Title will match or beat any other title company's rates where well, as long as they're not breaking any laws and having to do anything illegal, they'll match or beat any other rates. So if you give me that quote to Paramount Title will review that and they'll match or beat their rate. As long as we have a written quote, they will match it and they will beat it. So what I'm assuming happened is he just did some math in his head. The numbers just didn't add up. He did them the wrong way and he couldn't make heads or tails of it. Title came in, gave him that, said, yeah, bring me the quote. I'll match it. I'll beat it. I'll make sure that we get you made whole, but these are the rates. They don't change. So that other title company, I'm sure will be charging you the same amount. They're going to be the same fees, the same everything. So very, very simple thing to overcome, but we have to understand that these fees are not negotiable fees. These are promulgated rates from the state of Florida for all closings. The same way documentary stamp taxes on the deed are 70 cents per 100. These are 575 per 1,000. So that just gets those estimates put together. And so just understanding that. And then lastly, as far as the issues that we see are title issues. We have some automatic extensions built into the contract. So I want to be very clear about what these are because these come up not a lot, but when they come up, they're very, 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 very relevant. Whenever we have a title cloud, so the title company's job is to do a title search. Their job is to double check everything that they can find to make sure they can deliver a title that is free of any liens, encumbrances, debts, any issues. So what they do is a title search, and that title search is going to be, there's going to come up with a title commitment saying, this is our commitment to deliver a clear title, and here's any exceptions or issues that must be cleared in order for us to meet this commitment. And they provide that to the buyer and to the seller. It is given to every buyer and every seller, and the contract dictates what timeline that has to be given or provided in. So ultimately, the title company is not a party to the contract. The buyer and seller are, and the seller selects the title company. So the seller, if they select the title company, has to make sure that their title company is going to deliver the title commitment within the timeline afforded to him in the contract. And the timeline for the contract is going to be X number of days. We'll go up here. If left blank, at least 15 days prior to the closing date if it's a loan, and 5 days prior to closing if it is cash. So the title company has to be able to deliver that title commitment. Why? Because the buyer must be able to review it and look and see if there's an issue. So all parties have to review it and see if there's an issue. If there is an issue on the title that is going to prevent them from clearing title, or a cloud on title, or a defect on title, we have to notify the seller of such, telling the seller there is now a cloud or a defect on the title, and I'm notifying you of this issue, starts a clock. The clock says the seller shall have 30 days, which is a cure period, after receipt of buyer's notice to take reasonable, diligent efforts to remove the defects. The title commitment is the written notice that there is a defect, and we receive that, and we can go forward and try to clear that defect. And the seller shall have 30 days. Not may have 30 days, might have 30 days, write an extension for 30 days to make sure all parties agree to it. Seller shall have 30 days to cure this defect. That's it. Very simple. If the seller cures the defect within the period, the seller delivers written notice to the buyer with the proof that it's been cured, and we will close as per the contract if the closing date has not passed. If the closing date is still in line, we're still within the period before closing, we close according to the contract. If the closing date has passed, notice the contract says right here, if the closing date has passed, it automatically assumes that this 30-day extension might go past the closing date. We don't need an extension. And if the closing date passed, the buyer and seller will close within 10 days after the written notice from the seller that everything is cleared. Very simple. It doesn't say we need extensions. It doesn't say the buyer has to agree to stick with this. This is an automatic extension that the seller gets to clear, and the buyer still has the right to buy even if the closing date passes. It creates rights and obligations for both parties. The seller has the right and obligation, the right to clear, but also the obligation to use diligent effort and good faith to clear it. The buyer has the right to buy that home, even if the closing date passes, because the seller must use diligent effort and good faith, and the obligation to give the seller that 30 days. Very, very simple and very clear. The rights and obligations extend that if we get to 30 days and it has not been cleared because the seller used diligent effort and good faith and we haven't been able to clear it yet, now the buyer has an additional right. The buyer has the right to cancel and get their money back if they want. Why would they do this? Why would they force a buyer to stick with a contract if there's a title issue? Well, they realize that it says the title commitment should be delivered 15 days prior to closing if it's a loan. So we have a good period of time to cure if we get the title commitment out and the seller's able to notify that and try to cure it. Very simple. We can do all of those things within that timeline. But also, is that the seller's fault that there's a defect on the title? Not necessarily. Is it the buyer's fault there's a defect on the title? Not necessarily. But the buyer and seller both said they wanted to buy and signed a contract. So if something is outside of their hands, it's a third-party issue, they said that this seems fair. Give the seller the right to do that. If it takes too long, the buyer's not forced to stick with it. They can cancel. Or the buyer said they wanted the home. The seller is still trying to clear it. The buyer can extend for up to 120 days. And if after 120 days, it has not been cleared, then the contract is automatically terminated. Automatic if after 120 days can't be cleared. So those are just some issues that we've been coming up with. I just wanted to share them with you. A lot of them are revolving around compensation. Compensation is still being a big issue. A big issue with communication, buyers not understanding, sellers not understanding, seller agents and buyer agents not willing enough to communicate and connect, and still thinking that I've been doing this for this long. I've been doing it since the 90s and this is how it's always been done. It goes correct until 2024. Completely understand. So in this instance, your 30 years of experience doesn't get us anywhere, because in 2024 is when all of this changes. And at that point now, I'm the one who's done more of this knowledge, more of this training, more of the expertise in this, because this is what we've been doing and focusing on. So just some issues we have. Please do me a favor, continue to log in, show up for the daily training, show up for the classes that we have, get into Beggins University, utilize the tools that are there. I didn't have time to go through the seller updates, so we'll talk about seller updates. I'm still amazed at how little of us are giving seller updates and providing that, and how when I have to have conversations with a seller, they haven't received that. So let's do a better job. They're hiring us for a reason. Let's make sure we give them that reason. We show up like that. If you guys need anything, we're always available. It is May 20th, 9:30. You guys have an amazing day. Thank you so much.